Yes. Yes, yes.
Condition item number 10. Here, the state responsibility is to file anything.
Take advantage.
That's mine.
You are for the state.
Lost.
Huh?
I'm for the state. Item number 9. I'm allowed to stand to file my affidavit.
Now the entire initial regularization is under challenge. Right? College teachers. But there was a proceeding before this court earlier that it was upheld there. So how can they now challenge the earlier regularization? When are you filing it?
About the 2 weeks for.
On the prayer of the learned government advocate appearing for the state respondents, the matter stands adjourned, enabled to facilitate filing of their response by the state, filing of response by the state respondents. Registry to list this matter after 3 weeks on a date to be fixed by it.
May I please, Lordship? I'd like to mention item number 17. Lordship, respondent number 2 is indisposed today. Currently, the matter be listed after 3 weeks.
Wait. Indisposed to that extent, he's not coming to court for 3 weeks.
Lordship, it was informed to us.
Who is not keeping well?
Lordship, I am not in this matter.
Oh, we'll have it tomorrow. Today I'm accommodating. Registry to list this matter again on tomorrow's date, ma'am. Yes.
Your Lordship, in item number 30, I have received the affidavit of the state. There has been an oversight on my part for not including 2 necessary parties. Lordship, the Mission Director, NHL, and the Managing Director, Naga Hospital Authority, Kohima. And they kindly be allowed to.
They are at best NHM. NHM is not going to give you a regularization.
Yeah, Your Lordship, that is there.
There is no dispute with regard to the period of your service.
Yes, Your Lordship.
And the only thing is whether the course of action they have followed for the other category is to be followed for you or not. That's
yes, Your Lordship. That is the only thing, but since they have raised the issue and that was an oversight on my part also for not including them.
And that we will ignore. If you want, you file it, but we'll ignore. But that is not the material thing.
Your Lordship, and I have to file a affidavit in reply also, my Lord. So,
On the prayer of the learned counsel for the petitioner, matter stands adjourned for
3 weeks.
for further 3 weeks to enable the petitioner to bring on record a response, a rejoinder to the affidavit filed by the state respondent. Prayer is not objected to by the learned counsel for the respondents. Registry to list this matter after 3 weeks on a date to be fixed by.
Lordship.
Yes, madam.
So, Lordship, I'd like to mention item number 10. We're supposed, I'm appearing.
No, 10 is already adjourned.
Item number 9.
9 it was. Okay.
I'm appearing on behalf of private respondents. We were supposed to file our affidavit in opposition today. However, due to some difficulties in communicating with the clients, we were unable to do so. So we'll be filing in the course of today.
Course of the day.
Yes, Lord.
Mr. Masa, let them bring it on.
Kindly give me 2 weeks.
Okay, done. Ms. So-and-so, learned government advocate submits that an affidavit on behalf of the private respondents. For the private respondent submits that an affidavit on behalf of the respondents represented by her would be filed during the course of the day. Who is assisting you? Mr. Mr. Sentilong, learned counsel, assisting Mr. Takamasa, learned senior counsel, submits that he be granted further 2 weeks' time to file a rejoinder to the affidavit being filed by the on behalf of the private respondents. Pray accepted. Registry to list this matter again after 2 weeks on a date to be forced by.
Yes, Lord.
I may be allowed to on the order item, the Lordship. There was one, the last occasion.
You were supposed to file an, have you served that copy on the? But I think you will have to bring it on record by way of small affidavit because this is important.
The Lordship, regarding the affidavit, I have sent it for vetting, so it might be listed after a week.
Miss S. Chung, learned counsel. Miss Holy, learned government advocate, submits that the notice upon respondent number 5 has already been served and an affidavit in this connection would be brought on record shortly. She submits that she be granted a week's time, 2 weeks' time to file an affidavit on behalf of the state respondents. Pray accepted. A registry to list this matter after 2 weeks. The learned government advocate shall, along with the affidavit filed in response to the writ to the contentions raised in the writ petition, shall also bring on shall file an affidavit to bring on record the acknowledgement of the receipt of the notice of the present proceedings by the respondent number 5.
On top of my colleague, Your Lordship, is in this post today. Your Lordship, it may kindly be this after 2 weeks to file affidavit.
No, the code numbers, have you got it?
Your Lordship, since I'm not in this matter, but.
Just we'll call it up. Just give me a second. Anything else? Yes.
To mention item number 2, Lordship. Since we are yet to receive instructions from our client
For what? What instructions?
to file our affidavit.
Okay. Now tell me one thing. Is your client in receipt or his family in receipt of any family pension after the death of the government servant?
I have Mrs. Lordship, only this case.
No. Then see, you are in a ICDS project. That's a scheme. The compassionate appointment scheme will not apply to that institution, unfortunately. So if you can show that you are in receipt of a family pension, nothing like it. We will deem it that you are an employee. Now here you had passed away. After that, the posts of LDA drivers, there are 2 matters here. LDA drivers were all abolished or the salaries were not being released. So what is left here, Mr.? Got to make out a case in that line that your mere asking for compassionate appointment will not do. And if your client is not desirous to file a reply, Gone, case gone. Because their contention will be unrebutted then. And very categorical contentions. Giving you 2 weeks time. Bring your rejoinder on record. The learned counsel for the petitioner is granted further 2 weeks time to file a rejoinder to the affidavit filed by the respondents. No further adjournment shall be granted in the matter.
Worship, I'm appearing for respondent number 3, 4, and 5.
Ms. So-and-so is present for state respondents.
State response.
For respondents number 3, 4, and 5. Registry to list this matter again after 2 weeks.
May I please, Your Lordship? I beg to mention item number 2 of Lordship. Here I am appearing, I have an instruction to appear for respondent number 2, 3, and 4.
Now here again, whether pension was granted to her.
Lordship.
No. Sure.
Similar Lordship. Isn't that allowed?
No, have you got pension? Then you're in ICDS, you're a driver. You are not the arguing counsel. Are you doing this matter? So what do you say? Whether you are a regular government employee in a government establishment or you are in a scheme, what do you have to say on that? Okay, you read your brief. We will take it up when it's called serially.
For admission, item number 1.
May I please, Lordship? Lordship, I beg to mention item number 4. Lordship,
4 is already adjourned.
No.
Yes? 4 has been adjourned? No. I got it wrong today. What is happening?
Lordship, I'm appearing on behalf of Pakin Chavo, counsel for respondent number 26. Lordship, can you grant 2 weeks time to file affidavit in opposition?
Okay, let us let the matter which we'll see. Any other mention? Yes. Yes, have you provided the code numbers to her? Your code numbers? Huh? 7 and 8. Why? Why? They don't have a code number. Then why is it being withheld? There is a clear-cut order passed nearly 2 months back. You have to give it to her so that she can take further steps in the matter, right, ma'am? To the government council. Why?
Since there's living in remote.
Oh, they are not so remote. You for 2 months you take them. Come on, Nagaland is not that so remote. You have access nowadays everywhere. And what happened to the consideration with regard to the others? Okay. On the prayer of the learned counsel for the parties, registry to list this matter again on today is 18. On 25. You give that code numbers in the meantime.
For admission, item number 3.
You are coming back in the second half. You will be coming back in the second half. Huh? I'll dictate this to you then. And if the list finishes, I'll dictate inside. We'll pass it. Because if I start dictating, the others will have to wait. We'll pass the orders once. Just keep it up to that. When madam comes back, give it to me.
For admission, item number 4.
This Lordship. Lordship, I'm appearing on behalf of document also for respondent number 26. Lordship, can I grant 2 weeks time to file, 2 weeks time to file with opposition motion?
You were already granted time on 24/4.
Lordship, our client are from not luck, so they're taking time to come here to give up the documents. Lordship.
Yes, madam. What do you say? Your application is for appointment on compassionate grounds. You say that these private respondents in the meantime have been appointed. But your case for compassionate appointment has not been considered, although you are at serial number 6. Yes, who is for the government? Yes, why? 50% is declared, and I find that from 2019 onwards, more than one vacancies were available. If that is your policy, why the cases of the petitioners were not considered?
Lordship, it's appointment it happened in the election day. He's in serial number 5 in group C and group
6.
Lordship, 5 and 6.
Oh.
In group D, he's in serial number 6. And in group C, he's in serial number 5, Lordship.
I got it.
Lordship.
I found a list somewhere.
Then my election batch number 9 in the Lordship.
Come to page 27. Para 15. So when you can appoint as for land ownership, why not the compassionate appointees? They are in more need.
Okay.
Huh? You had enough vacancies. 22 posts of grade D. Grade D cannot be technical. It's just grade D. So in 23, you had 17 posts.
Lordship.
But you made no appointment on compassionate grounds. Why? Your affidavit is vague on that effect. Technical posts, which posts are appointed on the basis of land ownership? How do you appoint group C post against land ownership? No, it's only group D post. So, and these landowners, you have appointed in the same district many. And where are those reports verifying their claim from the deputy commissioner?
Lordship, I have not received that.
Then, if you are writing something, you have to support it.
Lordship.
It's nothing here. And those persons who have been appointed other than land owner category, there is no selection.
Lordship,
We will go for wholesale interference now. The petitioner would have well been appointed much long back. She's claiming an appointment on compassionate grounds. You have not said in your petition that she is well off, she does not require this. Mr. Your name? Assuming learned government advocate appearing for the state respondent submits that he be given a week's time to bring on record materials to demonstrate as to how the vacant posts arising both in Group C and Group D were filled up. He submits that he shall, after 2 weeks, he submits that he shall place on record the materials basing on which, they were placed on record the processing as well as orders passed towards appointing the private respondents as by reckoning them to be landowners and or landowners, full stop. He also submits that he shall bring on record the minutes of the selection proceedings involved leading to the selection of the candidates. Full stop. Registry to list this matter again after 3 weeks on a date to be fixed by it to facilitate the learned government advocate to bring on record the materials as indicated here in above.
For admission, item number 5.
May I please, my lord? May I please, my lord? Lordship, in this matter, the parties have agreed to settle a matter through mediations, your lordship. This matter can be listed before the mediation court, my lord.
Why mediate? I am mediating. Okay, tell me. I am mediating. Tell me. Tell me. Why have you not paid? Are you admitting?
No, your lordship,
Then-
I have not received.
Then what mediation?
I have not received.
Then what mediation? What are you going to mediate before the mediator? The only thing I require here is your admission.
Yes. Your lordship, that is what has been instructed by the department. Lordship, therefore.
No, if you are going before a mediator, the stand is you have to take a stand. You will not take a stand that you are going to agree. What is the point in mediation?
Lordship, since the parties have already agreed to it, lordship, if it can be.
Where is that agreement?
If an opportunity can be given.
I'm sorry. Yes, madam.
Well, lordship, if they're willing to,
They are willing to, not you. Then your claim is of 2001. You have instituted this proceeding after 24 years. What is the ground for your delay? What is the explanation for your delay?
we should be ready to go for the mediation.
No, I'm refusing that prayer. You got to answer this query. You're not filing an affidavit here.
I have not filed it yet, your lordship.
You want to file?
Your lordship, since the instruction is to go for mediation, your lordship, I cannot.
That will be just a wastage of time. Could be a wastage of time here. You file your response, then we will see. Mr. Chandra, learned senior government advocate, submits that he be granted further 2 weeks' time to file a affidavit on behalf of the state respondents.
Your lordship, may kindly record my submission that the department.
We will do it. We will do it once you file your affidavit. Once you file your affidavit. Without your affidavit, there is no point in sending this to mediation. Or give me an undertaking that you both have agreed to settle the matter through mediation.
Lordship, the
Both of
department
you.
has said that if the counsel for the petition also can submit that they are ready, and then we have decided to go for mediation, your lordship.
This is not a case for mediation. Prayer accepted, registry to list this matter again on 4/6/2026.
Your Worship, can you uh, 9/6?
9/6/2026.
I'll give you.
No further opportunity shall be granted to the respondents to file an affidavit in the matter. You file an affidavit, if you agree therein, then her limitation goes.
Correct.
If you don't agree, then we'll have to decide the preliminary issue. That much will be.
And
For admission, item number 6.
On instructions, I think you're not going to this petition.
Charge sheet's filed.
No, the petition has been dispatched.
Discharge
Yes.
from the criminal case. So what happened to the Departmental proceedings?
It may go on, so I think we allow some legal to.
Okay.
At least, let me address all this person.
Okay. The learned counsel for the petitioner, Mr. L. Iralu,
Yes.
submits that the petitioner desires not, the petitioner in view of the subsequent developments taking place, desires not to press the matter, thus press the present writ petition any further. Accordingly, he prays that he be permitted to withdraw the present writ petition with liberty to refile the same if the occasion so arises. Prayer is not objected to by the learned counsel for the state respondents. Accordingly, in view of the submissions made by the learned counsel for the petitioner, the present writ petition stands dismissed on withdrawal with liberty as prayed for.
For admission, item number 7.
The respondent is yet to file.
Oh, why? A long time. Why the names of the petitioners are not included in the district list and you have limited it to 2009? To that, this decision is of 24, you don't have instructions, how can that be? And the selection is on the basis of merit cum seniority, I suppose, then?
Lordship, I'm about 3 weeks time to find.
No 3 weeks time, I'm sorry. We just want the reason why you have limited it to 2009. That's the only grievance you have. On the prayer of the learned counsel for the parties, the matter stands adjourned for 4 weeks. The respondents would be at liberty to file their their response to the affidavit ipso advised. What is this? You should take advantage, my dear.
For admission, item number 8.
(152) removed.
No, my lord. My lord, as per the last order, power
Why?
grid has been.
Why the delay? It's there in time now.
Yes, my lord. We have written to because there's the.
You have been writing for a long time. Your earlier counsel had undertaken that he will remove.
Yes, my lord.
Handle this matter earlier.
Yes, my lord. What happened is, my lord, the new line in which it has been surveyed, my lord, the new land owner, there's some objection to that regard, my lord. That's why there's been.
I'm sorry. That's not the impression you had given. Your earlier counsel had given. Mr. Khera had given this code. You said he said that the decision is already there to string the electric line.
Yes, my lord.
151 to 153.
Yes, my lord.
152, which is above the land of the petitioner, will be removed. Why?
Yes, my lord. Yes, my lord. But for that, my lord, for the direct stringing, my lord, it goes through the land of new owners, my lord.
No,
So
there is no problem. You have the right. You only have the right of way only. You're not acquiring any land.
Yes, my lord. And because of the obstruction by the new land owner, my lord, we have written to the DC also, my lord, and we are still awaiting any action by the DC into that regard, my lord. My lord, we will bring on record the communication which have communicate with the Deputy Commissioner, my lord.
No, last occasion we had given you time till today to either shift the tower or acquire the land.
Yes, my lord.
Citizen in doldrums like this. She is hanging. The petitioner is hanging for a long time now.
Absolutely, my lord. But my lord, for that, because there is a, because the new landowner, there's some, there's obstruction from his part.
Use
in-
your, this is under the Electricity Act. You have
Yes, my lord.
precedence,
Yes, my lord.
you're not acquiring.
Yes, my lord. For that regard, my lord, we have written to the DC, my lord, for him to. for the
Writing
DC
will not do. Writing will not do.
to exercise the power under 16(1) of the Telegraph Act, my lord. So
16(1) is for them to go, not for you.
yes, my lord, we have written
We
a
will
communication to
for
DC
the
to invoke that power.
dismantling of that 152 and disconnection of the electrical line now.
Yes, my lord.
Shall I pass that order?
No, my lord, may you kindly give us 1 week's time, my lord. We'll bring on record the communications.
We don't want the communications. We want the implementation of the decision.
Because, my lord, the decision has been taken to directly stringing from 151 to 153.
And that decision, Mr. Counsel, was
Yes.
placed before this court on 2/2/2026, February,
Yes, my lord.
April, May. Then again in March, you had made certain further.
Yes, my lord. Owing to the.
So we are interfering with that order by which she was restrained from carrying out querying activities. Let her carry out querying activities. You
My lord,
consequences.
may kindly allow us to
No,
first
I'm sorry.
the direct stringing, because, my lord, if my lord may kindly see our additional affidavit, the
I'm
query
not concerned. I'm not. It's of no use.
It's in very close.
Kera had given the undertaking same submission, and this court had, what the last order said, can be shifted, or in the alternative may initiate action under the so and so for acquisition of the right of way over the land of the petitioner. Neither
Yes,
you.
my lord. No, my lord, we have written to the DC to
Yes, but
exercise this power on 16(1), my lord. For that, my lord, it has been done, my lord.
Your Lordship, as per the last orders, they are to either shift the tower or initiated actions to be taken as per the Indian legal government. So, since we already did it for 2 months, and also no step has been taken, I need proper order.
Because right of way in her case may not be permissible because this is at a height, her land is below. So if she query here, undertakes the querying activities below the thing, that will fall down. That will be dangerous.
Yes, my lord.
You give me an undertaking that you are going to comply with the last order, I will give you an adjournment. Otherwise, I'm not.
My lord, we have written to the DC, my lord, to exercise.
I'm sorry. I'm sorry. I'm sorry.
Obstruction by the new landowners on the
I'm sorry. I'm
this
sorry.
direct stringing is happening, my lord.
I'm sorry. That's not the orders passed by this court.
My lord, may kindly have the last order. We have directed also, my lord, to take a fixed step to the deputy commissioner, my lord.
And or
yes, my lord. Yes,
in alternative. How can you play with a citizen's right like this? You can't.
My lord, we are not, my lord. The decision has been taken that we will directly stringing from 151 to 153, my lord. However, in that process, my lord, the new land
You already have 153 there. You have 152 to 153 line going. What are the submissions you are trying to make now?
My lord, from 151 to 153 for direct stringing, my lord, the line will go into the land of the new parties, my lord, new landowner. So that landowner.
You won't be changing the alignment. Then you will have to have another post somewhere. How can that be?
No, my lord, we are not changing alignment.
You have 151. You have 153.
Yes,
there is a line moving from 151 through 152 to 153.
Yes,
it's that thing now.
My lord,
now, to remove 152, you can string straight from 151 to 153. It will be the same route.
No, my lord, there is slight change in the alignment, my lord. That's fine.
Then you will have to have another pole another tower somewhere. Where are you planning that tower?
No, we're not required to put another tower, my lord.
Then
my lord, where that line will go through the land of a new landowners involved in that.
Okay, what steps have you taken to have right of way over those lands? Where are your documents envisaging that?
My lord, can you have our additional affidavit?
No, after the order passed by this court on 26/3.
My lord, we have.
What steps have you taken?
We have written a communication to the DC, my lord, to exercise his
So
power.
that has not happened. That has not happened.
To remove
That has not happened. That has not happened. So why have you not taken the alternative route? Acquire the right of way of the petitioner's plot.
My lord, we have taken steps to the deputy commissioner because, my lord, there's obstruction, and the deputy commissioner is having a power under 16(1) to remove such obstruction. So, my lord, we have accordingly write a communication to the deputy commissioner. If my lord may kindly allow us, we'll bring on record that also, my lord.
We are not. Mr.
T. Margar. Otherwise, my lord, may kindly have after 1 week, my lord will come with proper
Mr.
instruction.
T. Margar, learned counsel appearing for the respondent number 6 and 7 has submitted that they have taken all requisite steps for compliance of the directions passed by this court by the order dated 26/3/2026. However, on account of the inaction on the part of the Deputy Commissioner, Mokocham, Nagaland, that is the respondent number 3, the requisite steps in the matter could not be taken. The matter could not be taken to its logical conclusion. On the next date of listing, Mr. Margar, learned counsel for the respondent number 6 and 7 shall place before this court the steps taken by them in the matter after the passing of the order dated 26/3/2026. The learned state counsel appearing for the respondent number 3 shall also complete his instructions in this connection from the respondent number 3.
Plan for respondent number 1/6.
Hmm.
Here we have filed our affidavit number 1/5. And there we have clearly stated what. 20th of April.
What have you stated?
Lordship, our role, Deputy Commissioner role, will get only confined to the jurisdiction role. So, Lordship, we have issued the restraining order and thereafter, Lordship.
Okay, you complete your instruction. They say that they have now written communications to you for right of way, and you are not taking any steps. Complete your instructions on that. Come back. Okay, I'm not asking you to file an affidavit. Just receive the instructions from the Deputy Commissioner.
In fact, we have filed
No, don't dispute on that. But you get that instructions also. After their communications, after 26/3, what have you done? Raised it to list this matter again on 4/6/2026. 4/6.
Highly obliged, my lord.
For admission, item number 11.
Mr. Imsong, why is this being delayed?
24 March 2026, 11/5. Worship asked for a direction of the order dated 24 March. We filed the affidavit on 4th of this month. But again, there were some errors that were sent back. And now is a very specific case regarding the Indigenous. So
that's what I've been hearing from the day I have been handling this matter. I've handled this earlier also.
This is another sensitive issue. So far as the present petition is concerned.
Let Mr. Imsong make his submissions.
from the Departmental, we need some more time because these will be a floodgate. Floodgate for the Indigenous.
Hey, this cannot be accepted. You will have to bring on record your stand. You have denied him the indigenous certificate. Why? What is your stand on that? That much only we want.
Yes.
The rest we will take care. Whether it will open a floodgate, it will not open a floodgate, that is not for this court to look into. This court will only examine whether the reasons that you will now assign are within the periphery of the Constitution. That's all.
Okay, sir. Since the days of time isn't. So a short time will be given on the such direction. So as to enable us to.
Mr. I am learned additional Advocate General appearing for the state respondent submits that he be given a last chance to file an affidavit in the matter on behalf of the state respondents. The learned counsel for the petitioner, however, objects to such adjournment being given to the state respondents. Respondents. So, however, considering the issue involved in the present petition, a last chance is given to the state respondents to file an affidavit in the matter. So, no further adjournment shall be granted in the matter. Registry to list this matter again on 16/6/2026. In the event the affidavit is not brought on record, this court would proceed to consider the issues arising in the present petition basing on the materials already brought on record.
For admission, item number 12.
Are you getting is your family getting a pension?
Your Lordship, I have not been informed, but as per the office memorandum,
But you are in a scheme, not in a government job.
no, it wasn't like that. Your Lordship will see the appointment order. It is not under any scheme.
No, I said yes.
No, Your Lordship, the appointment order of the petitioner's father.
Where is that?
It's annexure C. Page 15. 14 is the annexure C, 15 is the type copy of it. Now subsequently, they are saying that all votes of drivers. No.
But these payments were being made under that scheme from the central government, 90:10. Central government has stopped that. That's why this letter of 2020. When did your father die?
He expired on 4/3/2020.
Okay. But Ms. So-and-so, your government advocate.
Worship, I'm the standing counsel.
Standing counsel, Social Welfare Department, appearing for the respondents number 2, 3, and 4. Prays that she be granted further 3 weeks' time to file an affidavit on behalf of the respondents represented by her. Also, no pension, you are sure for that.
Your Lordship,
You have your instruction. The learned counsel for the petitioner. Prayer accepted, huh? Also, learned counsel for the petitioner shall also receive instructions as to whether, in pursuance to the death of the father of the petitioner, the family has been authorized a family pension. Also, registry to list this matter again. 3 weeks, did you know? On 11/6/2026. Bring on record, madam. Many cases have come up now. And also highlight in that whether they are receiving a family pension.
For hearing, item number 15.
15, 16.
Please, my lord.
I've gone through. I will pass the orders. CAV. Huh?
Deeply obliged.
I'll pass the orders.
Today itself, my lord?
Not sure, because they are having much work. Once I get a bit, that's why I put it reserved. I've reserved the order.
Please, my lord. Lord, the interim order has not been continued last time, my lord.
Today, I've already heard the matter, so that interim order is merged with my final orders now.
Please, my lord.
For hearing, item number 18.
Please, Your Worship. So if you go by the order dated 11/2024, the petitioner has not complied with that order to inflict the other tribes.
8/11/2024. After the passing of that order, we have filed a review petition. The same was
Recall.
recalled with the liberty to file an appeal, but we never filed for an appeal. In the meantime, we have tried to contact the petitioners. But
Now tell me, what is left here?
Yes, Lordship.
This issue has been decided by this court,
Yes, Lord.
right?
Yes.
That the two types, I think it's ticket, income and ticket,
Lord.
they would be two different things. And the government has filed an affidavit, okay? And the order of this court is henceforth from that day. So they say that after that, we are doing that. Now what is left here?
No, Lordship, that they have admitted that we are doing it, but not in letter and in spirit. Because even in that advertisement.
Advertisement is before the orders of this court.
But even till date, even in the year 2026, it's going on like that. Income/ticket. So I have to share one post with the other party.
So, Mr. Imsang, you have already decided that this would be separate. They were earlier together, now it will be separate. Why is it not being shown in your advertisements accordingly?
Actually, for the notification 23, it is already complied with that with our advertisement. That is my affidavit.
Show me one such advertisement where you have complied with it.
First of all, something is here, if a judicial proceeding cannot, a judicial proceeding cannot attain the finality, if a specific order direction remains non-compliant. And this amount is it violates the authority of the court and the order renders there.
So you mean to say that they'll have to institute a contempt proceedings for that?
No, I have not seen that. But whether he pray for the question or alteration of that particular order, or they have to do something. This is a court.
No. They have said that, see, the state respondents are directed to implement their notification dated so and so in any appointment made for gazetted, non-gazetted post by taking necessary steps for its implementation. These orders was passed on 26/9/2023.
Yes.
That much, why are you not complying with that?
WBC 42.
Hmm.
That is posted one.
Hmm.
In the prayer, the petition and the present petition are same again.
Okay, I got it. We got it. But why is this thing not been complied with in the subsequent advertisements? Has it been complied with in the subsequent advertisements?
They don't worship. Even in the year 2026, they are still doing.
Okay, you have brought on record Annex K, page 68. Where is the thing that both the tribes have been taken together?
Lordship, in fact, may I take your Lordship to page 77 Annex K? Lordship, in item number 4, one post of Women Resource Development Officer, Class 2 Gazetted under Department of Women Resource Development. One post reserved for PT, EMQ/TK. So they have not implemented the notification. And even in the item number 8, same thing, Lordship.
Now, Mr. Counsel,
Yes.
if it is IMCUM or TIKIR separately
Lordship.
and together, what difference does it make?
Because earlier they were enjoying the same one because tickets were coming under UQ. Now that by a notification in the year 2022, tickets were recognized as a separate tribe. Earlier, 6 tribes of Tinsam, Mon were enjoying 25% reservation. So now by 2022 notification, they said 25%.
It will be 7 tribes now.
Should be, yes, equally shared.
Now you come to the advertisement, serial number 4.
Lordship.
So now we read this advertisement not by the word slash, but by the word or. IMCIM or TIKIR. That's what you want?
No.
Then?
It should be separately IMCIM or otherwise it should be separately TIKIR. That is what the notification says. Equally among the 7 tribes.
Equally among the 7 tribes.
Lordship.
I'm sorry, it's not equal. It's anyone. of those 7 tribes. And the distinction would be the marks scored by them. Whoever scores higher marks will get the reservation. Here, it's not a percentage divided between 7 tribes, but it's a percentage for all the 7 tribes. "25% of all categories so and so shall be reserved for the persons belonging to the following 7 tribes of 6 districts of so and so." So it's not, say, like you have made a reservation for scheduled caste, you have made a reservation for scheduled tribe, you have made a reservation for OBC. Here, within that scheduled tribe reservation, 6 castes have now been included, tribes have been included, and it will go to any one of them.
No, Lordship, there is a roster maintained by the NBC. Now it is for 200 per roster. Earlier it was 100. But thereafter they increased to 200 in view of the increase in the reservation. Now therefore, all these 7 tribes.
How is this reservation in the state applied? Is there any act rule for reservation?
Otherwise, there's 2017 Reservation Committee Act. There is an act.
There is an act. You have that act here?
In the previous round of litigation, the government said that it's still not enforced.
You have not gone up on appeal against that order, earlier order of this court.
No,
You can't ignore that.
you also, you go on affidavit. NHE, that is my affidavit is opposite paragraph 7, page 14. Actually, that the Constitution 29/2023 is already complied with.
How? Show me how you have complied.
NHK. No, not there is not F. No. NHK, serial number 8.
Annex K.
NHK.
D, serial number 8. It's Imkim was oblique tikir.
Oblique ticket.
And who are the candidates who have suffered because of this?
The aspirants.
The aspirants. Why are they not before this court?
Lordship, that is because the YA is an apex body.
Fine, we got it. But this selection, there would be some candidate who was deprived according to you. Who is that candidate? There is no candidate here. Your Honor, before a writ court, not a PIL. This is not a PIL. Then. So where is that candidate gone? That means there is no candidate who is aggrieved by this. What right do you have to? Who are you? Whose right are you exposing?
I'm exposing the right of the.
In connection with the recruitment process.
The aspirants.
In connection with the recruitment process, once you connect it with the recruitment process, there has to be somebody who is aggrieved. General, I can understand. But once you connect it to a recruitment process, then the person aggrieved would be required to be addressed.
Not therefore, Lordship, I'm not in any way challenging the recruitment process. I'm only asking for this honorable court to make it.
That's already there. That's already there. That's already been said by, that already has been laid down by this court while you ordered it at 26/9/2023.
That is not in compliance.
You should have filed a contempt then. How can I pass the same order again? Think over it. On the prayer of the learned counsel for the petitioner, registry to list this matter again on 26/5/2026.
Lordship, may I pray? In this connection, we have also communicated to the petitioners since we are unable to contact with them. Apparently, on the December of 2025, new team has been set.
So
Now we are unable to contact with them.
Then you withdraw.
Therefore,
Then you withdraw.
we have informed the petitioner if they no longer wishes to proceed with the case.
You withdraw.
Withdraw.
Withdraw it.
So
Withdraw it on the next.
on the next day, after 3 weeks.
No. Persons are suffering, so we will have to clear that off earlier. I'm asking you, I'm giving you time only on the question of law. That's all. Think over it. Yes.
For hearing, item number 19.
None appears for the petition on 19. Yes, madam.
Thank you so much. Monsignor has some personal difficulties today, so
Okay.
that this matter can come up next week.
Thursday. On the prayer of the learned counsel for the parties, registry to list this matter again on Thursday. 2 persons already appointed, ma'am. So your thing goes. Private respondent, we will take care.
For hearing, item numbers 22, 23.
First issue. How is this repetition maintainable here?
The lordship may kindly recollect similar matter.
No, maybe.
I'm coming to that.
I got it. There were 2 repetitions which were disposed of.
There's similar matter and the respondent has filed an appeal. An appeal happened to listen before your lordship once. Lordship has given me one case law in Polanat and also to the respondent on the question of mentionability. Lordship, if your lordship may.
What happened to that appeal?
That appeal has been disposed of, your lordship.
Why? By directing?
By upholding the direction.
You have that appeal.
No, my lord, there are actually 3 directions in that particular judgment. There has been first present, second past. The first direction was there. The petitioners were the state has been asked to regularize the service of the petitioner. And secondly, my lord, initially, what was done by the learned single judge has made regularization for the date of appointment, but that has been subsequently modified. That regularization should be made from the date of the passing of the order. And there is last direction, my lord, the department can proceed with the advertisement. Operative portion, page 34. The direction was given to regularize, not with effect from the date of the initial appointment, but regularization, yes.
Okay, same order, we'll pass.
Oh, my God, there are 4 repeats.
Hmm.
And your lordship, lordship, I want that lordship query, your lordship. Yes. I have a very short submission to make, my lord. So far as the item number 20 and 21 is concerned, my submission is going to be significantly short. But I'm of firm belief that so far as the item number 23 is concerned, my lord, our case is not covered by this judgment.
Okay. And then 24, 20, 23, 20, 21, 22, 23. How many are there?
Well, there are 4
20, 21, 22, 23. 20 and 21, we keep it aside. 23, what is your objection?
Yeah. Just a moment. My lord, the basic fact of this case is that there is a particular observation made by the Honorable Supreme Court in Umar case that Regularization of the employees can be considered if those contractual employees completed minimum of 10 years of service, right? So those who has completed minimum of 10 years of service, they can be considered for regularization as a one-time measures. And secondly, if we understand, my lord, legitimate expectation is not an absolute right. It's basically a procedural safeguard. And here in this particular case of the petitioner, my lord may kindly come to the petition. I am specifically referring to just a moment, my lord. My lord may kindly come to para number 2. I'm reading the first sentence. That I advertisement number so and so for a walk-in interview dated 10/8/2015 issued by the Central Institute. So she has not been appointed following an exhaustive process of selection.
Okay.
It is only an walk-in
Okay.
interview.
What have you done? Have you put this to challenge before the Supreme Court?
No, my lord.
Then here also, the mode of selection is by UPSC.
The mode of selection should be by a
Then you have accepted this.
Yeah, the selection.
Any other objection, Mr. Dekar?
No, yes. She has not completed 10 years.
10 years when?
10 years from the date of her appointment.
When was she appointed?
She was appointed, my lord, just a moment, my lord. 10/10/2017. 10/10/2022, my lord. There's until this, now she has not completed the period of 10 years, my lord. And whatever time limit that has been prescribed by the Honorable Supreme Court.
Come to Annexure 6. Probindas. This is 2009. 27/11/2009.
No, I'm referring to IT number 23, my lord.
Dr. Lumpumet.
Yes, Doctor Lumkumar. This is also Lumkumar. It is he, your worship.
He. Okay. Oh, this is 2017.
This is 2007. Till date, he has not completed. Now, although Supreme Court in Kumaribi case has observed that those contractual employees.
But you agree that he was appointed against a sanction post?
Initially, he was appointed against the sanction post. But thereafter, he has resigned and accepted the post of, just a moment, my lord. Post harvesting expert. And that is not a sanction post, my lord. So here, in this particular context, my submission is with the moment somebody appointed.
Okay, we keep 23 aside for a time being. We allow 20, 21 and 22 in the lines of the division bench.
My whole submission is there, my lord. So far, there are 2 years that has been made. First, my lord, may kindly take Renewing Chetri, that item number is 20. Yes, my lord. My lord may directly come to the prayer portion in this particular matter. My lord, there are 2 paragraphs. Prayer A was directly respondent to absorb regularize the service of the petitioner as assistant horticulture specialist in CIF. To that extent, my lord, her case is fully covered by the judgment of the
Second one, we are not allowing.
Second point.
We are not allowing.
Then, my lord,
only her regularization against the post she was appointed. Thereafter, what happens, right?
Thereafter, my lord, she was asked to hold the post of horticulture.
That we will not. Because our regularization will be, because our appointment is assistant horticulture specialist, we will go by that only. Then
I have no further making.
So you also agree that these 3 matters, it will be covered by the division bench judgment?
To some extent, right?
Not to some extent. To the extent of regularization of their services against the post they were appointed. That much.
That's what. Again, my position for a moment come to item number 22, Intero Jamil. internal zoning. Now, again, in the first prayer matter, she has prayed to absorb her and regularize at the post of PhD Director CI. This used to be the sanction post. But in prayer B, she has sought regularize in a post of admin and account expert. This is not a sanction post.
Okay, we'll go by the prayer number 1 only.
Prayer.
And what about the
This matter fully covered by this adjudication. And in that treated matter, I have no further sanction. This is my clear admission.
And we know Mr. Decca, that's why we have asked him.
But I have big resentment that a case of Mosusang Longkumar is covered by this investment.
But Mr. T.B. Jamil, learned counsel appearing for the petition, item number 20. Also heard Mr. Decca, P. Decca, learned CGC. You are appearing as CGC. CGC for the respondents number 1, 2, for all the respondents. Mr. T.B. Jamil, learned counsel for the petitioner, has submitted that the case of the petitioner, that the case of the petitioner is squarely covered by a decision of the division bench of this court in by judgment and order dated 7/3/2026, passed by the division bench of this court in WA number 12/2025. So the said prayer, Mr. Decca fairly submits that the claim made by the petitioner in the present proceedings, would be covered by the decision of the division bench of this court in the above noted case. So I've heard the learned counsel for the parties. Hearing concluded. Registry to list this matter again on
regarding 23.
2020 on tomorrow. Kali, I'll pass the orders.
Yes.
Tomorrow for delivery of orders. 21. Same, had Mr. So-and-so, same. So Mr. T.V. Jamil submits that the case is covered by so-and-so. Mr. B. Decca, while submits that the prayer number A of the petitioner in the present proceedings would only be covered by the decision of the division bench referred to above, while the prayer number B would not be so covered. Same heard, closed, heard, Kali delivery orders. C, 3. Same, Decaro same.
Your Lordship, in 21, Your Lordship, it's fully covered. Your Lordship.
No, second, the prayer number B.
No, prayer number B in context of item number 20. Not the item.
In
Item 1 is fully covered by.
Item
21 is fully covered.
Oh, sorry, Potham to 21 over day. Potham to order dilu, it to 21 over. Second to 20 over. Third to 22, same. 23, as agreed to by the learned counsel for the parties, registry to list this matter again on when? No, you are coming. Mr. Jamir is always here.
Because Your Lordship case also is fairly covered.
He is having a doubt. Let him have his. Let him make one more trip to Kohima. Why are you denying him that pleasure? 9 June, done. On 9/6. Okay, Mr. 9/6/2020. Those 3, give me the files. I'll list it tomorrow. I'll pass the orders.
For hearing,
Otherwise, your lordship, regarding that on maintenance, your lordship, I have this given one.
No, division bench has said, I still have my doubts about that. It cannot be taken up.
Civil Service Officers Association is your lordship.
No, that is that I was there. That R.K. Agarwal, R. Agarwal against versus.
State of Assam.
Just show me.
State of Assam. On this matter. State of Assam referred by Chief Secretary regarding this appointment to IS, Assam Civil Service Officers Association. Para 20, 21, 22, and 24 squarely covers your lordship. L. Chandra Kumar has been discussed. Thoroughly, your lordship.
I had appeared for the second petition there, Rakesh Agarwal. I had appeared for him. But by the time I was elevated, this judgment came subsequently. Because that's the point they had taken. That you cannot come here, you will have to go before the. You have missed out on an opportunity, can't help it.
Last time, when the matter was submitted in best, I could not be present. Because one of my relatives has expired. But the learned judge was of the opinion that since it is a covert case, so CCC may not be had while pronouncing the judgment.
Okay, fine.
But this is a circumstance that arises.
Okay, fine, we understand.
I am not able there, my lord, to question the judgment that has been.
You cannot, I cannot. How can you then? I cannot. My hands are tied. Even I am covered by the decision of the coordinate bench in this matters. I may like it, I may not like it, but judicial discipline demands that I should follow it. And I'm following it. We are allowing that. But where Mr. Jamir, whenever next time you get matters like this, service matters, central government, now we have a very good setup in Gauhati with Central Administrative Tribunal. I think you should also go there. It will be enriching that institution also.
We have circuit bench here.
And circuit bench also come here. I think participation from this bar would enrich that institution also. Yes.
Thank you.
for hearing, item number 24.
Yes, Mr. Devi.
Yes.
Why excess? Why excess?
Not because petitioner was appointed without the approval of the government.
Government. So what is this great thing about the approval of the government? Can an approval by the government to otherwise an invalid selection give that selection a validity?
Selection.
Okay.
There was no selection at all.
So do one thing. I am directing that she will not be entitled. At the same time, I find the advertised impugned orders here. All this have been appointed without selection. So I'm interfering with those also. Illegality has come to my notice. I'll only say, give them a hearing and then ask them to go, because they are not party respondents here. You have not made them party respondents. So that much I can give you. We can't help it. She is there from 2009. No,
Okay, let us take one at a moment.
No.
Because
She is there from 2009. After 2009, you have made recruitment right and left without any selection process. Even your advertisement in your affidavit does not say so. But you now come back and say that she is excess. If she is excess, she is not appointed against a post. How are you paying her salaries? You're receiving her salaries?
full benefits.
Full benefits. How? From where? From where are you giving her salary if there is no post? you can't give someone salaries if there is no post.
We are giving the scenario and from the schedule. But
You're giving the salaries against a particular post which she is holding.
appreciate one difficulty of the government. Director has appointed the petitioner.
She is working from 2009 against a post.
Correct.
More than now 16 years,
Yes.
15 years.
Yes,
You
Correct.
cannot deem her to be against a non-sanctioned post.
no, largely procedure that followed in the state. Director has to recommend to the state.
It's just a technicality. It's a technical. It's a technicality. It's just a technicality, a technical procedure. It's just a procedural lapse. You can still do it.
You see, Lordship, we have processed
Okay.
case of the petitioner
Okay.
to the BNR department also.
Okay.
Now.
This is the post
I would
of.
say that.
This is the
He's
post
not
of.
serving the department.
No, this is the post of.
Serving the department.
What is the post? Sub-inspector of supplies. What is the cadre strength?
Lordship.
Cadre strength. Mr. Zumi, what is your cadre strength?
Existing characteristic, I am not aware.
Cadre strength as on the date you were recruited.
Your Lordship, I don't have that figure out.
1. 2. If you are being given all the benefits,
What benefits come on? Revisions of pay, disability to the pension,
everything,
GPF,
GPF, GIS.
everything.
Yes, sir. What do you say? If this is the form, huh?
I don't deny that. I don't deny submission.
You will not.
But there is a problem.
Okay. You rectify that. But she will be deemed to be a regular incumbent in the cadre, considering the other appointees, the manner in which the other appointees have been appointed.
That would be in my individual opinion. It is a decision that the backs for.
Which case?
I have all the backs for approximately 90 feet.
You like it one paragraph? One paragraph, my paragraph 3. Repetition. Paragraph 3. Repetition. A categorical statement that I was appointed on a regular basis. I know. There is much about that. I have to, and look at the reply in the government section of the. Government section of paragraph 3.
No comments. Yes, which decision do you want to rely upon? Miss Metsi, she is serial number. Julie Metsi. Serial number 8. Same appointment. Only difference is that last line, administrative approval of the government.
That is why.
We will ask you to do that. Deemed approval. She is working under your nose.
Worship, please see 2013, volume 2, SSC, page 516, paragraph 43.
Oh, police officer's case. There is a latest decision of the Supreme Court that if it's on the negative side, that if the appointment is not against a sanctioned post, no regularization can take place. If I apply it the other way, If it is against a sanctioned post, it is deemed to be regular. And that's the system you follow in the other cases. So she is entitled. Can you give me that cadastring thing so that I can affirmatively record a finding that you are against a sanctioned post? Both of you. Sub-inspector's cadastring. Just give me in writing from your director. That will do. I'll keep it on Wednesday after the division bench. Any problem? No problem. Heard the learned counsel for the parties at some length. Your additional government, no, senior government advocate, appearing for the state respondents is required to place on record in writing received from the Director, Food and Civil Supplies, Nagaland, the cadre strength of the post of Sub-Inspector of Supplies as on the date the petitioner was so engaged, while order dated 30/4/2009, along with the man in position in the said cadre on the said date. Director shall also furnish the cadre strength as on date and the man in position. For so. From the materials on record, it is seen that the petitioner is being extended with all service benefits as would be mandated to be extended to a regular appointee, and the same would go to reveal that the petitioner's appointment was against a sanctioned post. In the event the said position is not, in the event the position is not so, the director to also clarify the same on the next date of listing. Registry to list this matter again on, put it on Thursday. Thursday. Just get me that. And but please do so. We have already spent some time. Give me that. Can you call that? Can you call that? You call. So let's see how it works out. Otherwise, my view is very clear. You can't put a person to trouble like this. The other appointments were regular selection. Then I would have said, Mr. Yomi, please forget it. Apply for regularization. But here, your government approval is only to the application, not to the selection, unfortunately. Who am I to say that? I'm only saying the precedence that is on record. That's all. Nothing more, nothing less. Give me that item number 2. She is coming? Yeah, allowing it. But you will be under suspension. They are at liberty to proceed with the inquiry. We say from the stage of, because you filed the written statement from jail. So from the stage of filing your written statement to the memorandum of charge. From that day, they will take it forward, complete it at the earliest, and you will be under suspension till that time. From the date of your dismissal till the date of conclusion, you will be under suspension. Madam is here. Madam, come. Mr. T.O. Lankumet. This is item number 3. Have your seat, Mr. Lankumet. Heard Mr. T.U. Longkume, learned counsel for the petitioner. Also heard Mr. You are appearing for the, who had appeared the last date? Keyword, what is that name? Get that name for learned government advocate appearing for the state respondents. The challenge in the present writ petition is to an order dated 30/11/2023 issued by the Superintendent of Police, Mokocham, Nagaland, imposing the penalty of dismissal from service upon the petitioner on conclusion of a departmental proceeding instituted against him. Give me that Nagaland service. So, next para, 3. The facts in brief requisite for adjudication of the issues arising in the present writ petition is noticed as under. The petitioner what is the date of the show cause notice?
There's no date.
Is it before your arrest or after your arrest? Before your arrest. Was issued with a show cause notice requiring him to explain with regard to his consumption, use and procurement of narcotic substances. Also, while the said show cause notice was so pending, the petitioner was arrested on 1/7/2023 in connection with Mokocham PS case number 12/2023 registered under section 21 bracketed B of the NDPS Act, basing on an allegation of possession of contraband substances. On the petitioner being placed under detention, the Superintendent of Police, Mokocham, Nagaland, wide order dated 3/7/2023, proceeded to place the petitioner under suspension pending withdrawal of departmental proceedings against him. Thereafter, a memorandum of charge dated 4/7/2023 came to be issued to the petitioner, framing 2 articles of charge therein. Also, on the same day, wide an order dated 4/7/2023, the disciplinary authority of the petitioner proceeded to direct for holding of an inquiry with regard to the charges framed against the petitioner, while the said memorandum of charges dated 4/7/2023, and for the purpose appointed an inquiry officer as well as a presenting officer. It is to be noted that at the relevant point of time, the petitioner, in connection with the police case, was behind the bars. It is Sapara. It is projected in the writ petition that although the petitioner was behind the bars, he had prepared a written statement of defense against the said memorandum of charge dated 4/7/2023. However, he was not allowed to submit the same by the disciplinary authority. It is projected that an inquiry was held within the prison premises wherein the petitioner was so detained, and on conclusion of the said inquiry, the inquiry officer submitted a report in the matter, holding the charges leveled against the petition to have been established. So, the disciplinary authority of the petitioner, on a perusal of the said inquiry report, without however forwarding a copy thereof to the petitioner, proceeded via the order dated 30/11/2023 to concur with the findings of the inquiry officer and thereby hold the charges leveled against the petitioner via the memorandum of charge dated 4/7/2023 to have been established. Basing on the said conclusion, the petitioner came to be imposed with the penalty of dismissal from service. The petitioner thereafter submitted a representation dated 11/3/2025 before the Director General of Police, Nagaland, praying for revocation of the order of penalty on the ground that he was not given all due opportunity to defend his case during the trial. During the inquiry, also, the said representation, however, not being considered, the petitioner had instituted the present proceedings. Mr. T.O. Lonkume, learned counsel for the petitioner, by reiterating the facts noticed herein above, at the outset has submitted that although the inquiry was conducted in the presence of the petitioner, the said inquiry was so conducted within the prison premises. He submits that the petitioner had participated in the inquiry. However, he being under detention, it cannot be expected that the petitioner had so participated in the inquiry with a free mind. Mr. Lonkume has then submitted that the inquiry officer, while carrying out the inquiry, had not permitted the petitioner to cross-examine the departmental witnesses deposing in the matter. He submits that the inquiry officer had thereafter submitted an inquiry report holding the charge leveled against the petitioner to have been established. However, the disciplinary authority had not forwarded a copy of the same to the petitioner herein, as mandated under the provisions of Rule 10 bracketed Roman 3 of the Nagaland Services bracket discipline Roman and appeal bracket over rules 1967. He submits that in absence of the inquiry report and the other materials, copies of the evidences as well as documents exhibited in the inquiry, a prejudice had occasion to the petitioner in preferring an appeal in the matter. He submits that in terms of the decisions of the Honorable Supreme Court holding the field, the inquiry report is to be furnished to the petitioner prior to the consideration thereof being made by the disciplinary authority for imposition of a penalty. Mr. Lunkume, T.O. Lunkume, learned counsel for the petitioner, has further submitted that while the memorandum of charge dated 4/7/2023, the charge framed against the petitioner was with regard to possession of 0.927 grams of suspected brown sugar (sunflower) (oval). Mr. Longkumer, by referring to the inquiry report now brought on record by the state respondents in their affidavit, has submitted that the inquiry officer in his said report had not dealt with the said charge. There is no finding recorded that the said charge stood established against the petitioner. Mr. Longkumer, by taking this court through the findings of the inquiry officer, has submitted that the allegation proved against the petitioner was different from that was so alleged against him in the memorandum of charge dated so-and-so 4/7/2023. He submits that the charge framed against the petitioner at best can be said to be one of consumption of contraband substances. However, he submits that there was no allegation leveled against the petitioner in this connection in the memorandum of charge dated 4/7/2023, right? Accordingly, he submits that is there any provision here that during the inquiry, if some other charge comes up, then that has to be inquired in the matter by issuing an additional charge sheet? Do you have any provision in your rules? I'm not going into that prosecutor judge thing because they had appointed a. Also, Mr. Longkume has further submitted that from the materials produced in the present petition, it would be evident that the forensic lab report with regard to the substance purportedly recovered from the petitioner was so received on 18/3/2024 by the respondent authorities, and the inquiry conducted in the matter against the petitioner had concluded on 30/8/2023. Accordingly, he submits that on the date, submits that in the inquiry, there was no material brought on record to establish that the substance recovered from the petitioner, suspected substance, contraband substance recovered from the petitioner, was actually brown sugar, no? Heroin was actually heroin. Huh? But in the charge sheet, it's brown sugar. So what was that in the charge sheet? Brown sugar. Brown sugar, heroin is a further refined version of brown sugar, right? Or it's something else. Okay. Having made the above submission, Mr. Next para, Mr. Longpere has further submitted that in terms of the provisions of the rules of 1967, more particularly Rule 4, Rule 2, which mandates that the disciplinary authority shall frame definite charges on the basis of the allegations existing against the delinquent and shall serve a copy of the such charges together with a statement of allegation on which they are based to the delinquent, who would now be required to submit a written statement of defense in the matter. He submits that for the purpose of preparation of a written statement, the delinquent is also entitled to pray for inspection of the listed documents. Thereafter, to submit a written statement of defense. He submits that in terms of provisions of subrule 4 of Rule 9 of the said rules of 1969, the disciplinary authority on a receipt of the written statement of defense may itself inquire into such charges as are not admitted by the delinquent, or if it considers necessary to do so, appoint for the purpose a board of inquiry or an inquiring officer. Mr. Longkume submits that the stage for appointment of stage for determination of a state for arriving at a decision as to whether an inquiry is mandated to be held in a matter would be so arrived only after the submission of a written statement of defense by the delinquent within the time frame prescribed, and or non-submission of such written statement within such time as may be prescribed by the disciplinary authority in the memorandum of charge. He submits that in the case of the petitioner, along with the memorandum of charge issued to him, order directing for holding of an inquiry, coupled with the appointment of an inquiry officer and a presenting officer, also came to be issued to the petitioner, which he contends to reflect the predetermined mind of the respondent authorities to hold the petitioner guilty and to impose upon him a major penalty. Anything more?
So, this on the question of natural justice, since it is a quasi-judicial procedure.
Then, per contra, Mr. So-and-so learned government advocate appearing for the respondents have submitted that the memorandum of charge dated so-and-so 4/7/2023 was duly served upon the petitioner in the jail premises. The petitioner was also served with the copy of the order directing for holding of an inquiry in the matter. He submits that the petitioner did not object to such departmental proceedings being instituted against him while he was under detention. It is submitted that the petitioner had never submitted a written statement of defense in the matter, and accordingly, on conclusion of the period for submission of such written statement of defense, also in view of the fact that there was no prayer for extension of such time, the authorities proceeded to approach the jurisdictional chief judicial magistrate with a prayer to permit conduct of such departmental proceedings against the petitioner, departmental inquiry against the petitioner within the jail premises wherein he was so detained. Good. The learned counsel submits that during the proceedings of the inquiry, which was spread over 3 days, the petitioner had never objected to the conduct of such proceedings within the jail premises. Also, it is submitted that the witnesses were so examined in presence of the petitioner, and the petitioner had not sought for cross-examination of the departmental witnesses that had the witnesses who had deposed in the inquiry. It is submitted by referring to the statements made by the petitioner in the inquiry that the petitioner had admitted to the charges leveled against him via the memorandum of charge dated so and so. Also, it is submitted that the statement as adduced by the petitioner before the inquiry officer brings home the guilt of the petitioner, and accordingly, the findings recorded by the inquiry officer in his inquiry report would be a report being based on the materials coming on record in the inquiry would not mandate any interference. The learned government advocate further submits that the petitioner, during his deposition, having admitted to drug abuse, the charge leveled against the petitioner stands proved, and for the matter, the absence of the forensics laboratory opinion would be of no consequence. In the above proposal, it is the learned counsel for the respondents further submit that the petitioner, although had an opportunity to prefer an appeal against the penalty imposed upon him, such appeal was not preferred by the petitioner, and he had, after lapse of around 1 year, 4 months, submitted a prayer petition to the Director General of Police Nagaland for reversal of his order of dismissal, which he said was not in terms of the provisions of the rules of 1967. The learned counsel for the respondents further submit that the petitioner, having not objected to the conduct of the departmental proceedings while he was behind bars, conduct of the departmental proceedings in the jail premises, while he was behind bars, The said issue cannot now be permitted to be raked up by the petitioner in the present writ petition. It is submitted that there is no pleading also brought on record in this connection. He submits that no prejudice having been caused to the petitioner on account of such conduct of such inquiry within the jail premises, this said contention raised by the contentions raised to the contrary by the learned counsel for the petitioner would not mandate an acceptance from this court. Right? I have heard the learned counsel for the parties and also peruse the materials available on record. Also, the background leading to the institution of a departmental proceeding against the petitioner has been noticed herein above, and the same not being disputed is not reiterated. Also, the petitioner, while a memorandum of charge dated 4/7/2023, the petitioner, while memorandum of charge dated 4/7/2023 was charged with 2 articles of charge. The charges framed against the petitioner, as evident from the statement of articles of charge appended to the memorandum of charge dated 4/7/2023, being relevant, is extracted herein below. Page 23, A to A, whole thing. Para. A perusal of article of charge number 1 would reveal that it was alleged against the petitioner therein that he was arrested on 1/7/2023 in connection with Police Station -1, Roman 1, Bigha, Mokochong case number 0012/2023 under section 21 bracketed B NDPS Act for possession of 0.27 grams of suspected brown sugar bracketed sunflower. While a perusal of article of charge number 2 would reveal that it was alleged that the petitioner, being a member of a disciplined force, having got involved in a criminal proceedings, he had acted in a manner unbecoming of a member of a disciplined force. The inquiry report has been brought on record by the respondents in the affidavit filed by them. This is para. On a perusal of the said inquiry report, it is seen that the inquiry was spread over 3 dates. The first 3 dates, that is 28/2023, 26/8/2023, and 1/9/2023. Please check up these dates. If there's anything, tell me. First of all, from the said inquiry, from the report, it is also revealed that departmental witnesses had deposed in support of the charges framed against the petitioner herein. The petitioner is also found to have participated in the inquiry proceedings. Also, on a conclusion of the inquiry, the inquiry officer had recorded the following findings. Page 21, B to B. Subpara. In view of the said findings, The inquiry officer proceeded to hold that the charge framed against the petitioner was established beyond any reasonable doubt. Also, as noticed herein above, the allegation, next part, as the allegation against the petitioner is with regard to possession of suspected brown sugar, bracket sunflower. This court, on a perusal of the inquiry report, does not find that the inquiry officer had come to a conclusion that that from the materials available coming on record in the inquiry, it was established that the substance recovered from the petitioner was in fact brown sugar. In absence of a conclusion being drawn by the inquiry officer that the substance recovered from the petitioner was in fact a contraband substance, the specific charge under article of charge number 1 leveled against the petitioner cannot be held to have been established. The article of charge number 2 being nothing but a derivative of the article of charge number 1, the same, in absence of the main ingredient of article of charge number 1 being established in the inquiry, also cannot be held to have been established. From the findings of the inquiry officer extracted herein above, this court finds that the inquiry officer had drawn a conclusion to the effect that the petitioner had admitted to his involvement in abuse of drugs. The same may be a factor which can be held against a delinquent, more so when he is a member of, against the petitioner, more so when he is a member of a disciplined force. But for the purpose of the disciplinary proceedings instituted against him, such conclusion would be of no consequence, inasmuch as a corresponding charge to the said effect was not leveled against the petitioner in the memorandum of charge dated 4/7/2023. A perusal of the conclusions, findings number bracket में 4, normal 4, would reveal that the inquiry officer had drawn a conclusion of the petitioner being actively involving himself in politics. The same may be a typographical error, but the same also reflects the fact that the inquiry was conducted in a casual manner without appreciating the actual charge framed against the petitioner herein. Also, next, at this stage, this court would consider the report of the Forensic Science Laboratory, Nagaland, Dimapur, dated 8/3/2024, placed on record by the learned comment. A perusal of the said report would reveal that the sample taken purportedly from the possession of the petitioner on examination had been found to be diacetyl morphine, bracket heroin, As noticed herein above, the inquiry against the petitioner had concluded on 1/9/2023, and the penalty was imposed upon him on 30/11/2023. Accordingly, neither on the date when neither during the inquiry held against the petitioner nor on the date the disciplinary authority had passed the order dated 30/11/2023, the report of the forensic science laboratory was available before the respondent authorities, inasmuch as the same was forwarded to the respondent authorities only on 18/3/2024. Accordingly, the conclusion reached by this court herein above that the charge of the petitioner being in possession of suspected brown sugar admittedly was not established in the inquiry, inasmuch as the same could have been so established only upon a receipt of the expert opinion from the jurisdictional forensic science laboratory. This court foresaw the findings of the inquiry officer admittedly reveals that during the inquiry, it had come on record that the petitioner was in the habit of drug abuse. However, the same being not a charge framed against the petitioner, the disciplinary authority, the inquiry officer could have drawn conclusions thereon only after a charge with regard to the same was so framed against the petitioner if required by way of issuance of an additional show cause notice. In the case on hand, there was no such procedure adopted by the respondent authorities, and the inquiry officer, ignoring the charge framed against the petitioner, proceeded to draw conclusions in his inquiry report with regard to the charges for which the petitioner was never charged and which were unconnected with the charges so framed against the petitioner. Accordingly, this court is of the considered view that the findings recorded by the inquiry officer, extracted herein above, cannot be held to have established the charge originally framed against the petitioner via the memorandum dated 4/7/2023. Foresaw the disciplinary authority, for the purpose of imposition of the penalty of dismissal upon the petitioner, via the order dated 30/11/2023, having concurred with the findings of the inquiry officer, and this court having found such findings of the inquiry officer to be of no consequence, the basis of imposition of the penalty upon the petitioner having been vitiated, the penalty as imposed upon the petitioner via the order dated 30/11/2023 would not mandate an acceptance from this court. For the reasons assigned herein above, the penalty as imposed upon the petitioner via the order dated 30/11/2023 stands set aside. The petitioner is directed to be reinstated in his services and shall be deemed to be under suspension with effect from 30/11. Shall be deemed to have continued under suspension with effect from 30/11/2023 in continuation of the suspension ordered in respect of the petitioner via the order dated 3/7/2023. As this court has found the order of penalty to be not sustainable, the penalty imposed upon the petitioner to be not sustainable, basing on the conclusions drawn by the petitioner and also in absence of a finding to the effect that the ingredients of the charge number 1, article of charge number 1, as framed against the petitioner stood established, comma, the other grounds urged by the learned counsel for the petitioner in the present proceedings is not being examined in the matter by this court. Is not being examined by this court. First, this court having interfered with the penalty as imposed upon the petitioner, basing on a technicality, comma, this court also having directed that the petitioner shall continue under suspension, comma, this court grants liberty to the respondent authorities to proceed de novo against the petitioner, basing on the charges framed against him, while the memorandum of charge dated 4/7/2023 from the state of submission of written statement, from the stage of issuance of the same, the petitioner shall now be permitted to submit his written statement of defense in the matter, and the disciplinary authority shall thereafter follow the provisions of Rule 9. Rule 7, no? Rule 7. Procedure is Rule 9. 9. No, 8 or 9 9. Procedure 9 of Rule 9 of the Rules of 1967. As the petitioner has now been directed, the petitioner has now been deemed to have been placed under suspension, comma, the petitioner would be entitled to his subsistence allowance with effect from 30/11/2023. The respondent authorities to compute the areas of such subsistence allowance and release the same to the petitioner within a period of 2 months from the date of receipt of the certified copy of this order. However, the current subsistence allowance be duly released to the petitioner forthwith. With the above observations and directions, the present petition stands disposed of. Something is there, I'll just make it clear. Say, I think I'll have to incorporate that. If there is any additional charge you have against him, you can issue a additional show cause notice to him. I'll give you that liberty also. Because this is a dangerous charge. Consumption of, because you may become a complicit to the persons who are involved in the trafficking. That's the only fear I have. Anyway, very nicely prepared. And I'm keeping it. Thank you.
tay complete होना नहीं ये जो कि दिशा दे पड़े no Shala हाँ मुझे मत दे tay लोगों कुछ दे दे आई वो Oh, yes, I do. You
nhưng mà có bệnh nhân như vậy ta hay xin chở nó em xưa bệnh nhân rồi mình biết sự này cái đấy thì phải cái chuyện kia em một như vậy chắc phải có em xưa bệnh ba sẽ mà phải ba nữa ta nhưng có cái gì mà cái 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 này cái chỉ phải làm sao
我看你帮大家，
哦，原来就是不能帮我们是指我你就好来，你就好不有的人听我们，包括很些。那在这的话，每天，我，呀，我来来来，
Item number. I get password on na. Ay, mangyeste.
en nasıl bir de çok en bir şey olursa bana de bu lava punya kita en nasi
En na. En dot na.
turun çok büyük.
집에서.
Zaten hayvan nasıl da beraber aydın kiman nasıl yapıyor
Kire. Check ko.
ama
Na. Ini na dito just lambat.
itu kelas itu deh
Lagi.
Yes, but I'm sure I'm that. So good, what's this?
Rektas na. Ini foto na. Wait. Itu lagi tidak.
But like we cannot use as this. Yes,
배우신나? 저도 거듭이나? 알아도 나이나? Item 203132 203132 itu tuh just ada ini ya. 203132
Oh, ya jalan ke. Wah.